Good evening, friends. And
Good evening, sir.
those who have joined us. Good evening, friends.
Good evening.
Belated Happy Diwali to everyone. And today's session will be the nitty-gritties in respect of the NDPS Act. And Mr. N.S. Rupra, a senior advocate, has already done one session with us on specific performance. Therefore, keeping in view his vast knowledge, we requested him to take this time and perspective, which is closer to his heart in respect of NDPS Act, the search and seizure. Today's journey again would be a bilingual language, as we did earlier session with him. And earlier, like I told, that since I have also been close connections with Jabalpur, therefore connection with Mr. Rupra is on a different level and pedestal. Over to you, sir, and thank you for accepting our invite.
Thank you very much, Vikas Chatraji. In fact, I have got high appreciation for you because you are motivating me to do something very, very academic, which also happens to be my interest. My desire always has been that I should be in a position to help the youngsters. Recently, I got one case in which a person under NDPS Act was behind bars for 2 years. And the moment I read the file, I compared the cases with Union of India versus Mohanlal, 2016, Volume 3, SCC 379. I was surprised to note that it was a fit case for acquittal, in which the matter was pending in the High Court for 2 years. I got the matter listed and argued. Judge immediately, Honorable Anuradha Shukla Madam, she has got great knowledge of NDPS Act, I have seen. She immediately got the point. The sole point was that the samples have to be taken in the presence of the magistrate. So immediately I got the bail, and it clicked to me that why so many people now, with the grace of God, I am not in need of cases. I have got so many cases that I have no time for that. But I want to guide the youngsters so that they should not suffer because of some point which has been missed. I am surprised to see that even with due regards, district judiciary, many district judges do not have the knowledge of Union of India versus Mohanlal. It's a very important judgment. You must know about it. Now, I request all the youngsters who are listening to me to put your pencil in your hand, because I'm going to tell you some rulings which are going to help you in the performance of your NDPS cases. And now, most important thing is that if you fail in NDPS case, what happens? Your client goes behind bars for 10 years. Now, 20 kg of ganja is a commercial quantity. I was seeing this heroin. Heroin is, I think, that also 250 grams commercial quantity. So the moment it becomes commercial quantity, then your client goes behind bars for 10 years and fine minimum of 1 lakh. So you have to be very, very cautious. But I like one sentence of Calcutta High Court. That is a ruling. I like that ruling very much. 2024 SCC Calcutta 6916. Azul Sheikh. 2024 SCC Online Calcutta 6916. Azul Sheikh versus State of West Bengal. Division bench comprising Joymala Bagchi and Gaurang Kant. A very nice sentence he has written. Honorable Judge says that it is right. Graver the offense, stricter is the proof. Procedural safeguards in the Act relating to search, seizure, and sampling, etc., have been engrafted to protect individuals from false implication and ought not to be ignored. Really, I'm so happy Calcutta, Madras High Court, in fact, all High Court judges I have seen across the country, some beautiful judgments come. But as I am making a video for all India appreciation, I will focus only on the Supreme Court judgment. So to एक judgment मैंने Calcutta High Court की दे दी because I liked it very much. The whole thing is that, as I said, Section 20, Section 18, any section of NDPS, Narcotic Drugs and Psychotropic Substances Act, you take, the moment it is a commercial quantity, your client goes inside for 10 years. So how to defend the case? To start with, Section 42 empowers the police to enter, search, and seize drugs, which he has reason to believe to be liable for confiscation under the Act, and any document or other article which he has reason to believe may furnish evidence of commission of any offense under this Act. If officer has reason to believe that a search warrant or authorization cannot be obtained without affording an opportunity to the accused to escape or conceal the evidence, then he can enter directly after recording the reason. Now, this is permissible, unfortunately, only when he is entering a dwelling house, a hotel, a stable place. But that is not the situation in case of Section 43. There is a difference between Section 43 and Section 42. So please take advantage of Section 42 and insist that where is the satisfaction of the officer to show that there is urgency to enter and I can't obtain warrant of possession or all that, a warrant of arrest or a search warrant, etc. So that recording is required along with reasons in case of Section 42, which is not required in the case of Section 43. Now, what is the difference between 42 and 43? Section 42 requires recording of reasons for belief and for taking down information received in writing with regard to commission of an offense before conducting the search and seizure. Section 43 does not contain any such provision, and officer has got the power of seizure of the article and arrest of person in possession of any narcotic drug in a public place. Now, in the case, this has been clarified by many Supreme Court cases. I'm dealing with S.K. Raju versus West Bengal. That is 2018, Volume 9, SCC 708. In that case, the appellant was walking along the picnic garden road when the search seizure was done. So it was held that Section 42 requirement is not required. So that deals with two set of sections, 42 and 43. Now let us come to the next protection, which is Section 50. Conditions under which search can be conducted. This is also very important for our defenses, young boys, young lawyers. Now, all of you are boys in front of me because of the numerous years which I have put in anyway. Where any officer is about to search any person under Section 41, 42, or 43, he shall, if the person so requires, take such person to the nearest gazetted officer or magistrate. He has to tell that this is your right to be searched and in front of only a gazetted officer or a magistrate as per your choice. Now, search of the person. I'm very sorry. I don't agree with one judgment of the Supreme Court, but it's a judgment of Supreme Court. I have got to tell you, the prosecution will become very happy to hear about this judgment. State of Haryana, HP, Himachal Pradesh. State of HP versus Pawan Kumar, 2005, Volume 4, SCC, page 350. This is a 3 judges bench of the Supreme Court. 8/4/2005 को decide हुई. Because I was a government advocate for 2 years, but I have been throughout my career a private advocate only, always mostly arguing for the accused. Sometimes the complainant also engages, but more cases are of the accused. But this Pavan Kumar, this says that search a person ke liye, you have to tell him. The officer is required to tell him that, listen, you got a right to be searched in front of a gazetted officer or magistrate. Search of person. अब Supreme Court says person means person. Now I'm carrying a bag. So that bag is not my person. So for the purpose of search of the bag or suitcase which I am carrying, there's no need to tell me that, look here, you got a right to be searched in front of a gazetted officer. ये सुप्रीम कोर्ट की जजमेंट है, क्या करें, फॉलो करने पड़ेगा. Now it has been followed in 2-3 other cases. Many of you all will be appearing for the prosecution on this, so be happy. Followed in Rajesh Dhiman versus Himachal Pradesh, that is 2020, volume 10, SCC, page 740, and G versus NCB, 2021, volume 14, SCC 592. As I said in the beginning, you please sit down with pen and paper, because many rulings I'm going to tell you. Even when you are appearing for the accused, it is always my advice to study the rulings which are in favor of prosecution, because in those rulings also, you come across some material which is in favor of, look, here is the distinguishing feature. Now, for example, this SK Raju, I just now told you SK Raju said that 43, in a case of 43, does not contain any such provision. An officer need not record all those reasons. वो तो prosecution वाले खुश हो गए वाली बात सुनते. But no, SK Raju, 2018 volume 9 SCC 708 also has a very good point in favor of the accused person, because it lays down a very important law. Search conducted was not only of the bag which the appellant was carrying. Bag में उसके heroin थी, cocaine था, कोई narcotic substance था, psychotropic substance था, narcotic था. But his body was also searched. When his body was searched, 2,400 rupees was found on his body, on his person, in his pocket. So the Supreme Court said that no, since the body was also, bag was searched, the narcotic was found in the bag, but your body was also searched, in which 2,400 rupees was found. So therefore, this is not a case which will be covered by the exception of Pavan Kumar, and section 50 ka protection will be available to you, meaning thereby that the accused will have to be communicated that, look, gentlemen, you got a right to be searched in front of a gazetted officer or a magistrate. Now, there is one more judgment. 2018, volume 18, SCC, page 540, Mohinder Singh versus Punjab. In this case, 7 kg of opium was carried in a bag, which he was carrying in a scooter. So, bag, pehli baat to, secondly, scooter. So, the Supreme Court said that Section 50 protection will not be available to Mohinder Singh, that is the appellant. However, Mohinder Singh was acquitted because of some other reasons. Ye sari various situations, you please pen down these situations and use all these situations when you are appearing for accused or for the prosecution. Now, same Mohinder Singh versus Punjab acquits Mohinder Singh, but not on that point. In that, he said Section 50 protection will not be available to Mohinder Singh because the drug was found in a scooter, kept in a bag, not on his person. So Section 50 was not available to Mohinder Singh. But Mohinder Singh got acquitted. Why did he get acquitted? Because the prosecution did not prove that the contraband seized from the accused was produced before the magistrate. The record, the order sheet must reflect either that the contraband was produced before the magistrate, or there should be conclusive proof that it has been destroyed, Because in the absence of contraband, in the absence of the drug, how will you prove that it is 7 kg drug, this, that? So in that case, oral evidence, Supreme Court said, is not admissible. So this Mohinder Singh versus Punjab is important for you, because in your case also, the prosecution does not produce the contraband in the court and the order sheet does not record, then your client will definitely succeed. Aap jeet jaoge mukadma. Now, there are a couple of other situations. I want to deal with the latest ruling, because the Supreme Court has been changing the legal position time and again. So, and the standing orders have also been coming and then being repealed. So, I'm always dealing the latest Supreme Court judgments in which some situations are given, which will be identical to your case, and therefore you will get advantage. Now, there is another case, that is Surepalli Srinivas versus State of Andhra Pradesh. That is also 2025 SCC Online SC page 683. इसमें क्या 15 दिन उसने कॉन्ट्राबैंड को आईओ ने अपने घर में रख लिया, अपने ऑफिस में रख लिया. No, Supreme Court said keeping of the seized contraband by PW3 in a separate room in his office for 15 days could give rise to an allegation that it was substituted and some other items planted to falsely implicate the accused. Hence, the accused was acquitted. बाकी बात बाद में करेंगे. You have been practicing. I am also practicing for the last so many years. And the accused persons generally don't speak the truth in front of the lawyer. They don't speak lies. And I have seen in many cases that this person is guilty, but along with him, his brother, his friend, his jija, sala have all been implicated. Or he has been falsely implicated because some material was there with the police. They wanted someone whose neck can be hung. So this is what the police has been doing. I am very much particular that in our country, this drug menace must come to an end. But this does not mean that innocent people should go behind bars, that also for 10 years. Now, what the police does, we have been reading that the Indian Evidence Act in our LLB, confession made to accused person, confession made to police is not admissible in evidence. So here also, the confession of the accused is not admissible in view of Tufan Singh versus State of Tamil Nadu. Please note down the citation, 2021, volume 4, SCC, page 1. This has been followed in a number of other cases. Union of India versus Chainaram, Bhagwan Lal, 2024, SCC Online, SC 4952. तो confession of the accused is not an. उसमें भी पुलिस आपके बंदे को implicate करने की कोशिश करेगी. So you please defend your client on that point. Now, please do not worry about Bharat Amble versus State of Chhattisgarh. Always you will find that your opponent will be wielding, opponent means prosecution. If your opponent is prosecution, he will be wielding Bharat Amble versus State of Chhattisgarh. That is 2025 SCC Online 45. Now, this is a case where actually we have been succeeding in many cases when what the police does, there are a number of packets of, say, ganja or any other drug. So they all mix it, samras kar lete hain. Samras karke uske sample lete. So when they mix it, so which one is what is not clear. So that has been a ground of acquittal in many cases. Even it will be, today also it will be a ground of acquittal. But there is one judgment of Supreme Court. You study it minutely. It is not so much against the accused, but it is definitely dealing with a situation where minor irregularity committed by the police will not come in the way. I will read one or two points in that. The IO had mixed 73 packets and thereafter proceeded to draw 2 samples of 100 grams from the mixture. All the 73 packets were opened Contents inside them were matched. An identification panchnama was also prepared. एक जैसा कर. 2 samples of 100 grams each were prepared from the mixed ganja, after which 2 sample packets of 100 grams each and the remaining ganja were filled in 6 plastic packets and sealed, and seizure proceedings were carried out. Identification test by color was done. Thereafter, the 73 packets were bunched into 2 lots of a maximum 40 packets each, and representative samples were drawn, which were then mixed together to prepare 2 sample packets. Thus, मेरा तो ख्याल है illegality हुई है, but Supreme Court says it can be hardly be said that there has been any procedural lapse of Section 52A of NDPS Act. No. Section 52A का हो गया, पर अब सुप्रीम कोर्ट ने थोड़ा बहुत उसका in favor of prosecution ले लिया. चलो कोई बात नहीं, चलते हैं. Now this has been followed. There is another judgment. Now I have not told you that I am coming to Section 52A. Section 52A deals with disposal of seized narcotics and psychotropic substances. Disposal in 2 points. Firstly, you collect it, prepare a sample of it, and get it, sent to the lab. Yes, it is ganja, cocaine, heroin, whatever. This is one. And secondly, the remaining drug you destroy. So both things are equally, no. Second thing is not so important, but first thing is very, very important. Sampling for the purpose of sending it to the laboratory to check whether it is ganja, cocaine, drug, etc. But even the other issue dealt with in Section 52A is quite important. And with that, there is one ruling, Narcotic Control Bureau versus Kashif. That is 2024, Volume 11, SCC 372. 372. इसमें लिखा है, Section 52A1 specifies the procedure for disposal of seized contraband. Any deviation or delay in making the application under subsection 2 to the magistrate, or delay on the part of the latter on the magistrate in deciding such application, could at the most be termed as an irregularity and not an illegality. So this deals with disposal, but the Supreme Court is not like this as far as it is not like this as far as sending it for sampling is concerned. In that case, at the beginning you said that I said there's a very important ruling with which I got so many reliefs in so many cases. That is Union of India versus Mohanlal, 2016, Volume 3, SCC, page 379. Sample is to... Now, this Mohanlal deals with the issues that how the contraband should be destroyed, how this should be done, how that should be done. All that blah, blah, it deals with. That is very important. But I'm telling you, what is most important from our advocate point of view, that is para 16 of Mohanlal. Why we will go into all. Para 16 of Mohanlal says that उसमें लिखा है no sooner the seizure is effected and contraband forwarded to the officer in charge of the police station or the officer empowered, the officer concerned is in law duty bound to approach the magistrate for the purpose mentioned above, for the purpose of sampling, etc., including grant of permission to draw representative samples in his presence, which samples will then be enlisted and the correctness of the list of samples so drawn certified by the magistrate. In other words, the process of drawing of samples has to be in the presence and under the supervision of magistrate, and the entire exercise has to be certified by him to be correct. There is in our opinion no manner of doubt that the seizure of the contraband must be followed by an application for drawing of samples and certification as contemplated under the Act. Application has to be made without any delay. Now, this judgment, as I said, it is not dealing with this issue alone. It deals with so many big issues that there are standing orders that how you should destroy, how you should store, and government has been given so many recommendations that you prepare storehouses properly for these storage of all these contrabands, which are to be ultimately destroyed or dealt with, disposed of in whichever manner as may be permissible under the law. This is the main issue in this case. But this para 16 and para 19, which I read just now, has been highlighted by us in so many cases, and including in the cases of the Supreme Court. So all of you, please examine your case. In every case, मतलब every case नहीं तो in most of the cases, पुलिस क्या करती है? One inspector goes, one sub inspector goes, गांजा आया, गांजा को सीज किया, सैंपल बनाया, भेज दिया. This is not proper. This is not proper. This singular mistake on the part of prosecution will get you a acquittal. And if your client is in behind bars, please get the bail immediately. Now, why? As I said, this judgment deals with so many issues, but this particular para 16 is then repeated in so many cases. Because why I deal with latest cases? कि भाई सुप्रीम कोर्ट ने वो केस ओवररूल तो नहीं कर दिया. Now let us see. मोहनलाल 2016 वॉल्यूम 3 SCC 379 का देख लो कितने में फॉलो हुआ. नंबर 1 2023 ऑनलाइन SC 498 बोथीलाल वर्सेस इंटेलिजेंस ऑफिसर नारकोटिक कंट्रोल ब्यूरो. Now in this case what happened, the intelligence officer of NCB himself seized the heroin and took 2 samples from each packet, placing them in 2 plastic covers separately. कोई मजिस्ट्रेट को बुलाने की जरूरत ही नहीं समझी. Acquittal. दूसरा केस सिमरनजीत सिंह वर्सेस स्टेट ऑफ पंजाब 2023 SCC ऑनलाइन SC 906. इसमें क्या? According to prosecution, search was conducted in presence of district superintendent. अरे भाई बहुत बड़ा ऑफिसर of the superintendent of police of the tempo, which led to recovery of 8 bags of poppy husk which were concealed under tarpaulin. From each bag, 2 samples of 250 gram, 250 grams were taken and made into 16 parcels, and residue of poppy husk in each bag was found to be 29.5 grams. Now, act of Sub-Inspector Hardeep Singh drawing samples from all the packets at the time of seizure is not in conformity with Mohanlal. Mohanlal मतलब section 52 capital A. एक ही बात. मोहनलाल ने 52 कैपिटल ए को अच्छे से एक्सप्लेन किया क्योंकि हम लोग को समझ नहीं आता, सुप्रीम कोर्ट को बताना पड़ता है. सेम इज द केस ऑफ यूसुफ एलियस आसिफ वर्सेस स्टेट. दिस इज 2023 SCC ऑनलाइन SC 1328. In the absence of any material on record to establish that the samples of the seized contraband were drawn in presence of the magistrate and that the inventory of the seized contraband was duly certified by the magistrate, it is apparent that the said seized contraband and the samples drawn therefrom would not be valid piece of evidence in the trial. Once there is no primary evidence available, the trial as a whole will stand vitiated. This has been followed so many times by MP High Court. I'll give you a list of those cases. At the end, I'll request Mr. Chatrat to give you a list of all those cases. I was just going through one judgment of a Madras High Court. V. Vasantha Kumar, V for victory, Vasantha Kumar versus State Representative of the Inspector of Police, NIB CID. 2025 latest judgment है SCC Online Madras 6255. भैया तमिलियन बहुत इंटेलिजेंट होते हैं। एम निर्मल कुमार जज, वेरी नाइस जजमेंट, ब्यूटीफुल इंग्लिश, एवरीथिंग। तो साउथ इंडिया वालों को सरस्वती की कृपा है। तो इन दिस केस ऑल्सो same things were said. Section 50 of the NDPS Act not complied with, and Mohanlal's case, Section 52 dictum lays down. साफ लिखा, I'll read. It is also seen that in this case, samples of the contraband not taken in the presence of magistrate, which is a clear violation of Section 52A, and the dictum laid down by the court in Mohanlal's case. So nice judgment written by Madras High Court, my dear friends. So I request all of you, all especially the youngsters, that Diwali holidays must be going on, and happy Diwali once again belatedly. And I am telling you that utilize this Diwali holidays to pick up your old files of NDPS and put down all these rulings, search out similarities of the cases, and try to take advantage of all these, get honorable acquittal for your clients. Mr. Chatrat, if I'm required to say anything else, you please tell. Otherwise, that is my total message to the youngsters. I really want all of them to be. I'm not saying that North Indians are not hardworking. They are very intelligent, very hardworking. I'm also North Indian, though stationed in Jabalpur. But I'm telling you, good judgments and very good language I found of Calcutta and Madras. So I pointed out. I'll give you a list of all those rulings in which Mohanlal has been followed, and all these various points have been followed, in which acquittal has resulted. You should use those rulings, and because you decorate your arguments with rulings. Judge knows the law, but he feels happy if you also support your arguments with. अच्छा, मैं टोटल तो अंग्रेजी में बोल दिया।
हाँ, कोई नहीं सर, उन मौका ले लेंगे कैपिटलाइज कराने।
मैं आदेश बोला था कि अंग्रेजी और हिंदी में बोलने का।
कोई नहीं सर, ਅਸੀਂ क्वेश्चन नहीं देवांगे सर, ਜਿਹੜਾ ਤੁਸੀਂ ਟੌਪ ਦਿੱਤੀ ਹੈ, ਅਗਰ ਸਪੋਜ਼ਿੰਗ ਤੁਸੀਂ हिंदी च दे दो 10 मिनट, तो इट विल बी वेरी गुड।
हाँ, हिंदी च मैं 10 मिनट दे देना। हिंदी पंजाबी में सब बोल सकता, कोई गल, पर पंजाबी आई डोंट नो द टेक्निकल लैंग्वेज, बाकी बोलचाल की भाषा तो बहुत बढ़िया है, कोई दिक्कत नहीं। देखो जी, हिंदी में मैं ये बताना चाह रहा हूँ, सभी अपने जितने श्रोता हैं उनको ये बताना चाहता हूँ, मैंने जितनी रूलिंग बताई आप लोगों को, वो सब आप लोगों ने नोट कर ली होंगी। उन रूलिंग्स का क्रक्स मैं आपको एक बार रिपीट कर देता हूँ। जब भी आपके पास कोई मुवक्किल आए, तो आप उससे ये बात कीजिए कि उसको मालूम चला 10 किलो गांजा, 20 किलो गांजा, 20 किलो गांजा लार्ज क्वांटिटी हो गई, तो आप उससे पहले मुवक्किल से पूछिएगा कि आप बताइए कि जब आपको सर्च हो रहा था तो आपको जज उसने नोटिस दिया था अंडर सेक्शन 92, बताया था आपको कारण कि भाई वारंट लाना संभव नहीं है, या आप भाग जाओगे, इसीलिए हम बिना वारंट के आपको सर्च कर रहे हैं, और या फिर मेरा ये विश्वास है कि ये जो मटेरियल है ये कोई ड्रग है। इस प्रकार का सेटिस्फेक्शन आईओ का रिकॉर्ड करना बहुत जरूरी है। अगर आपके प्रकरण में नहीं हुआ तो आपको आपके मुवक्किल को उसका फायदा मिलेगा। अब ये धारा 42 और धारा 43 में थोड़ी सी भिन्नता है। अगर आप किसी के घर में देखो ना, 42 में क्या लिखा हुआ है, बिल्डिंग, कन्वेंस और प्लेस, और धारा 43 में क्या लिखा हुआ है, पब्लिक प्लेस और इन ट्रांजिट। आप अगर कहीं आपने उसमें जा रहे हो, कार में जा रहे हैं, या उसमें बहुत से क्लाइंटों का वो सूमो में जा रहा है, उसमें पुलिस ने रोका, तो उसमें वो धारा 42 का आपको एडवांटेज नहीं मिलेगा। ये जजमेंट मैंने एसके राजू की आप लोगों को बताई थी, आप लोगों ने नोट कर ली। 2018 का वॉल्यूम 9 एससीसी पेज 708 नोट कर ली होगी, उसको नोट करिए, अच्छे से पढ़िए उसको। फिर उसके बाद अगला प्रोटेक्शन आता है धारा 50। धारा 50 में हर एक अभियुक्त को जिसके पास कोई भी ड्रग है, उसको पुलिस को ये बताना पड़ेगा कि आपको अधिकार है कि किसी मैजिस्ट्रेट के सामने अथवा किसी गजेटेड ऑफिसर के सामने आपका सर्च किया जाए। अब ये सर्च करने का अधिकार तो उसका है, पर सुप्रीम कोर्ट ने 3 जजेस के बेंच ने, 2 जजेस में भिन्नता हुई थी, तो 3 जजेस की बेंच ने होल्ड किया है कि उसकी बॉडी को सर्च करने का तो ये कंडीशन है कि आपको बताना पड़ेगा कि आपको अधिकार है एक मैजिस्ट्रेट के सामने या गेस्टेड ऑफिसर के सामने अपने सर्च करने का। परंतु अगर आपके पास बैग है, अगर आपका सूटकेस है, तो आपको ये वाली प्रोसीजरल जो मैंडेटरी सेफगार्ड है, प्रोसीजरल सेफगार्ड, वो आपको नहीं मिलेगा। तो ये वाली जजमेंट है पवन कुमार की, स्टेट ऑफ हिमाचल प्रदेश वर्सेस पवन कुमार, 2005, वॉल्यूम 4, एससीसी, पेज 350, 3 जजेस की बेंच है, विच हैज बीन फॉलोड इन राजेश धीमन और जीतराम। 2 केस मैंने बताए थे, आपने शुरू में नोट कर लिया होगा। परंतु एसके एसके राजू में एक और बात, जैसे मेरी बॉडी में, जैसे मेरे पास बैग है, उसमें मैंने गांजा रखा हुआ है, तो वो तो उसमें तो सेक्शन 50 की प्रोटेक्शन नहीं मिलेगी। परंतु गांजा तो रखा है और साथ में पुलिस ने मेरी बॉडी को भी सर्च किया, उसमें 2400 रुपए मिल गए, तो सेक्शन 50 आ जाता है, क्योंकि आपने यूर पुलिस वॉज नॉट सेटिस्फाइड। तो ये तो हर केस में होता है। तो आई विल एडवाइज ऑल यंग लॉयर्स दैट प्लीज टेक एडवांटेज। क्या आपने, जब आप सपोज यू आर डीलिंग विद द ट्रायल, हाई कोर्ट के स्टेज पे नहीं, आप ट्रायल के लेवल हो, तो आप आईओ से पूछिए क्या आपने उसकी बॉडी भी सर्च करी थी। बोलेगा हाँ साहब, बॉडी भी सर्च करी थी। बोल ही देते, इनको कुछ नॉलेज नहीं होती, पुलिस वालों कोई नॉलेज नहीं। और सेक्शन 50 की तो विद ड्यू रिगार्ड हाथ जोड़ के माफी मांगता हूँ भैया, डिस्ट्रिक्ट जजेस को भी मोहनलाल की जजमेंट नहीं पड़ी, को मालूम ही नहीं है कि मैजिस्ट्रेट के सामने सैंपल लेना चाहिए। और ये तो बेसिक बात है, मेन पॉइंट जो सेक्शन पैरा 16 और मोहनलाल में लिखा वो यही है। खैर, तो मैं आपको, जैसा चत्र जी ने आदेश दिया, मैं आपको ब्रीफ में सारा बता दूं। मोहिंदर सिंह एस के राजू में ये वाली बात कही है कि अगर आपकी बॉडी भी सर्च होती है आपके बैग के साथ साथ, तो आपको सेक्शन 50 का उसकी प्रोटेक्शन मिलेगी, अर्थात आपको बताना पड़ेगा कि आप मैजिस्ट्रेट के सामने आप कर सकते हो अपना अधिकार चेकिंग करने का। अब अगली बात मैं ये बताना चाह रहा हूँ कि जो कॉन्ट्राबैंड है, जो ड्रग है, उसको अदालत में पेश करना बहुत जरूरी। क्या होता है कि किसी केस में उन्होंने लिख दिया ओरली दैट इट वाज प्रोड्यूस्ड बिफोर द मैजिस्ट्रेट, नहीं, इट मस्ट बी रिकॉर्डेड इन द ऑर्डर शीट दैट इट हैज बीन प्रोड्यूस्ड बिफोर द मैजिस्ट्रेट। पुलिस वाले को टेक, भाई ये ड्रग्स मैनेज बहुत बुरा है, इसका ये मतलब नहीं कि उनको कानून का जो अधिकार है वो भी ना, भाई ड्रग मैंने अगर 25 किलो गांजा लेके जा रहा हूँ, 25 किलो कहाँ है मैं देखना चाहता हूँ, नहीं तो प्रमाण पत्र कहाँ है कि ये 25 किलो गांजा जो है वो डिस्ट्रॉय हुआ, तो ये नहीं किया। तो इस प्रकरण में मोहिंदर सिंह वर्सेस स्टेट ऑफ पंजाब में जो है वो उनको इसी पॉइंट पर कि आप या तो प्रोड्यूस करिए या डिस्ट्रॉय करिए, क्योंकि उन्होंने कुछ भी नहीं किया था, ओरली लिख दिया कि मजिस्ट्रेट के सामने प्रोड्यूस हुआ, तो सुप्रीम कोर्ट सेड नो, दिस इज नॉट पॉसिबल, तो आप लोग इसको इसका ग्राउंड पे बरी हो गए। अब एक और त्रुटि पुलिस वाले करते हैं, अक्सर होती है, वो ये होती है कि माल आया और अपने माल खाने में रख दिया, 15 दिन पड़ा है तो नहीं, आपको एक्सप्लेन करना पड़ेगा, सुरक्षित रखा, बंद रखा। सुप्रीम कोर्ट ने सूरेपल्ली, SUREPALLY, सूरेपल्ली श्रीनिवास वर्सेस स्टेट ऑफ आंध्र प्रदेश 2025 की लेटेस्ट रूलिंग है, SCC ऑनलाइन 683, उसमें लिखा है कि अगर सीज्ड कॉन्ट्राबैंड एक सेपरेट रूम अपने इन इज ऑफिस में 15 दिन के लिए रख दिया, ये तो प्रिजम्पशन होगी कि वो चेंज किया, क्योंकि पुलिस वालों को रहता है कि कन्विक्शन होना चाहिए। और ये अगली बात मैंने बोली थी, कन्फेशन अक्यूज का जो है वो इट इज नॉट एन एडमिसिबल एविडेंस, उसमें जजमेंट तूफान सिंह वर्सेस स्टेट ऑफ तमिलनाडु की थी, वो मैं पहले बता चुका हूँ। आपके अगेंस्ट भारत आंबले की ही एक जजमेंट होगी जो कि मिक्सिंग पर थोड़ी सी प्रोसिक्यूशन को सपोर्ट करती है, थोड़ी सी, परंतु उस केस में उन्होंने जितने भी पैकेट थे सबका अच्छे अच्छे से उसको मैचिंग करी, कलर मैचिंग करी, फिर उसके बाद उसको मिक्स किया, काफी प्रिकॉशन लिए। अगर आप ये भारत आंबले की जजमेंट पढ़ेंगे, ये 2025 SCC ऑनलाइन 452 है, ये एकदम 100% प्रोसिक्यूशन के खिलाफ नहीं है। आप देखेंगे कि अगर आपके केस में इतनी बारीकी से अगर पुलिस ने एक एक पैकेट को एग्जामिन नहीं किया होगा, तो आपको मिक्सिंग समरस करने का आपको एडवांटेज जरूर मिलेगा और आपका क्लाइंट जो है बरी हो जाएगा। मेरी दिली इच्छा है कि ये जितने ड्रग माफिया हैं ये सब इनको बंद होना चाहिए, परंतु इनोसेंट लोगों को तो नहीं होना चाहिए, इसलिए मैं ये सब करता हूँ, इसीलिए हम अपन इतनी मेहनत करते हैं। और आपको मोहनलाल वाली जजमेंट जो है वो किन किन केसों में फॉलो हुई वो मैं बता ही चुका हूँ, वो आप फिर से नोट कर लें। बोथीलाल वर्सेस इंटेलिजेंस ऑफिसर, BOTHILAL, बोथीलाल 2023 की जजमेंट है। सिमरनजीत सिंह वर्सेस स्टेट ऑफ पंजाब 2023 की जजमेंट है। यूसुफ एलियस आसिफ वर्सेस स्टेट, ये भी 2023 की जजमेंट है। तो आप लोग को इतना अपने आज की तारीख में सिर्फ मैं इतनी बातों को रिपीट करके अच्छे से ड्रिलिंग करना चाहता हूँ। बाकी अगर NDPS एक्ट का कोई और मुद्दा उठाना है तो उसका अलग वीडियो बनना चाहिए, क्योंकि आज अच्छे से हमारे दिमाग में यही फिट हो जाए कि मजिस्ट्रेट के सामने ही सैंपलिंग हो, सैंपलिंग सीजर से पहले उसको बताया जाए तेरा अधिकार है भाई गजेटेड ऑफिसर के सामने होने का, अपने आप सर्च करवाने का, ये सारी बातों का ख्याल रखें। और समरस वाले पॉइंट पर भी आपको अक्विटल मिलेगा, ये वाले आंबले वाली जजमेंट आपके खिलाफ, भारत आंबले वाली जजमेंट नहीं है। तो बस आज के लिए मैं इतना ही, थैंक यू वेरी मच।
थैंक यू। जिस तरीके से आपने नॉलेज शेयर की, नॉट ओनली इन इंग्लिश एज वेल एज हिंदी, आई एम क्वाइट श्योर that their illumination at their homes because of Diwali was done, and now they have been illuminated in their mind because of the session and that topic which you have shared. Everyone stay safe, stay blessed, and let's celebrate the joy of knowledge as well as learning. Thank you.